Okay, good morning everybody and welcome to today's festive webinar. I'm Martin Green, the sales manager here at Alps, and I'm joined once again by our head of claims, Nick Copley.
Hi.
Hi. Now, we know that the Renters' Rights Act 2025 has created a lot of questions, particularly around how landlords will manage risk going forward. Our aim today is quite simple: to give you clear, practical guidance so that you can confidently advise your landlord clients. Now, this Act, which received royal assent on the 27th of October this year, is the biggest overhaul of private renting in decades. It's designed to give renters more security while offering responsible landlords a clearer, more structured framework. Now, in preparation, we are working with our underwriters to update the policy to make it fit for purpose in the post-Renters' Rights Act world. Now, we expect this policy to be ready by the 1st of March 2026, and we'll be providing updates closer to that time. However, we will cover some of the expected changes in this session. The new rent protection policy will be coming with an increased price point from the 1st of March next year, due to the extended time that it's now going to take to evict non-paying tenants. But it will also have enhanced cover levels, with the rent protection element increasing to £3,500 off the shelf and £5,000 on a bespoke basis. Now, during today's session, we're going to look at the mandatory compliance requirements that are on the horizon. We're going to look at how the updated legal expenses and rent protection cover works under these new rules, and also why referencing is becoming more important than ever. Now, as we go through today's webinar, if you do have any questions, please pop them in the Q&A section at the bottom of the screen, and we'll do our best to answer as many of them as we can at the end. So, without further ado, Nick, let's get straight into the changes.
Okay.
Now, one of the biggest changes that we've seen with the Renters' Rights Act is the end of fixed-term contracts. Obviously a huge change. Can you kick us off with this, please?
Yes, so this is a fundamental change effective from the 1st of May 2026. Now, you'll hear that date a few times in this webinar. The Renters' Rights Act removes fixed-term assured tenancies from that date. So most private rented tenancies in England will become assured periodic tenancies. So this is a new system based on rolling month-to-month tenancies that applies to both new tenancies signed on or after the 1st of May 2026 and existing tenancies which will convert automatically to the new system. The move to periodic tenancies is designed to create greater stability for tenants, allowing them to build lives in their communities without the fear of being thrown out at the end of the fixed period. But it also gives tenants the flexibility to end the tenancy just by giving 2 months' notice to their landlord.
Okay, so that sounds like good news for the tenants, but what about the landlords?
So landlords will lose the certainty previously provided by a fixed term, which would help them manage the tenancy length and then regain control of the property without the need for a reason after that period of time. The change increases the pressure on landlords to maintain compliance. We'll get into that, and we believe it necessitates good legal cover, as they can no longer rely on the fixed term ending as a solution to manage problematic tenancies.
Okay, so without fixed terms then, obviously Section 21 disappears.
So from the 1st of May 2026, that date again, Section 21 or no-fault evictions are abolished. So under the Housing Act 1988, Section 21 previously allowed a landlord to serve a 2-month notice without given a reason for the tenant to have to leave, provided it expired on or after the end of the fixed period. There were other compliance requirements as well, but that was essentially the what would happen. This mandatory route to possession is gone.
So how can landlords now regain possession of their properties?
So post May 2026, landlords must rely exclusively on the statutory Section 8 grounds of the Housing Act 1988, which have been expanded and updated. The key implication is that everything in the possession process must now be reasoned, documented and evidence. So landlords need to prove to a court that a certain ground applies if the tenant doesn't leave. And this means on occasions it will take longer to gain possession of a property. It makes the legal expense cover a valuable asset. The cost complexity and length of pursuing possession through the courts using the Section 8 grounds is likely to be higher than before, and it will almost certainly be significantly higher the period of time than it would be through the Section 21 route. So landlords need to be aware that it will be more difficult to regain possession of their property if they have a problematic tenant or a tenant who doesn't want to leave.
Okay, thank you. Well, let's look at one of the most common issues that we see, rent arrears.
Yeah, so non-payment of rent is the most frequent issue that we deal with. So to evict a tenant who's not paying, landlords will have to or could utilise mandatory ground 8 under Section 8 of the Housing Act 1988. I'll explain for those that don't know. The grounds under Section 8, the eviction grounds are split into mandatory and discretionary grounds. So this determines whether or not a court has got discretion over whether or not to provide an order for possession or not. So ground 8 is a mandatory ground. However, the threshold for eviction is going to be substantially higher than it was previously. So from 1st of May 2026, the required threshold to give notice to someone on ground 8 goes from 2 months arrears, so a full 2 months of not paying, to 3 months. And the required notice period, so after you've served notice, you have to give the tenant a notice period to leave the property. This is going up from 2 weeks to 4 weeks. The tenant must have 3 months arrears, both when the notice is served and at the time that the hearing takes place for the mandatory ground to be applicable. So this now means that landlords could have to go 4 months before they can before they could take any action, court action against a non-paying tenant. And this doesn't account for the period of time that the court will take to deal with the case. Discretionary grounds for sort of lesser arrears, ground 10 and ground 11, which is some arrears, or persistent arrears, are still available. So these existed previously. And the notice period for these goes up from 2 weeks again to 4 weeks. Using these grounds alone, though, there's an element of uncertainty. In most cases, we would not be recommending that a landlord seek eviction for rent arrears using these discretionary grounds alone. You'd want that mandatory ground 8.
Okay, so what you're saying here essentially is that landlords could go a number of months without receiving any rent at all.
That's exactly what I'm saying, yeah. So we already see delays of months for hearing dates when Section 8 is used, and then further delays for the bailiffs to be instructed by the court. We've got an extreme case that we're dealing with where a customer's used 11 months of rent protection cover. Wow. So the average rent in the UK is over £1,300. So, and you'll get cases where tenants have got themselves into a financial difficulty, a lot of the time not through their own fault, and then they simply can't afford to pay. So in those cases, we don't expect that we're actually going to be able to recover that rent back from the tenant. And without rent protection, the landlord could easily be left over £15,000 out of pocket.
Okay, so it's quite a significant chunk of change there. Whilst we're on that point about average rents, as we touched on briefly at the start, our new product is being adapted to be a banded product, which will allow landlords to get the right cover at the right price. The upper limit for the rent protection on the new product will also be increasing to £5,000 as well. Now, circling back to possession then, Nick, surely there's going to be instances where a landlord may want to sell their property?
Yeah, so to replace Section 21, I suppose, for responsible landlords, there are new mandatory possession grounds which have been introduced for specific circumstances, which are no-fault type scenarios. So ground 1, which already exists, can be used if the landlord or their close family want to occupy the property. It did exist previously, but required a landlord or their spouse to have previously used that property as their main residence and couldn't be used during the fixed term. Now we've also got ground 1A, which is where the landlord wants to sell the property with vacant possession. So the Renters' Rights Act will include some safeguards for tenants for when these grounds are being used. So there's a 12-month protected period for a new tenancy during which you won't be able to use those grounds to gain possession of the property. And both of them have a 4-month notice period. And there will be a 12-month ban on re-letting after any of those grounds have been used. And this is to prevent misuse.
Okay, so So clearly what you're saying is it's going to take longer to regain control of a property where there are rent arrears, or if they want to move back in, or if they want to sell the home.
Yeah.
Is there anything else that landlords need to be aware of?
There are, and what I will quickly mention now is that we are going to see the introduction of the private rented sector landlord database. So this is sometime in the future now, so it's expected to launch in late 2026. A mandatory sign-up isn't expected until 2027 or perhaps 2028. So landlords will be required to register themselves and their properties, providing details such as contact information, safety certificates, and landlords who fail to register on the database, we believe are going to be prevented from gaining possession using most of the grounds in Section 8, except for perhaps serious ones like antisocial behaviour.
Okay, so how's that going to affect legal cover?
That specifically from a policy perspective, when registration to the database becomes law, this will be a prerequisite to cover being provided. Looking at the thing as a whole, practically what it means is that if a tenant stops paying, for example, landlords need to follow a clear arrears process and should be documenting every step. It's likely that where a landlord has rent protection and a tenant is in arrears, we're going to invite the tenant to mediation as well, which we'll get onto a bit later. And given the complexity of this, legal expense cover is useful for ensuring swift and importantly compliant action. You don't want to be serving an invalid notice. Perhaps more importantly, rent protection cover will ensure that you're not left with no income from your property if the tenant has stopped paying rent whilst you are seeking to regain control of the property.
Okay, thank you. So looking ahead to next year then, I believe that the documentation behind it all is getting a little bit stricter too. Tell me about the statement of terms.
Right, so the statement of terms is going to be a new obligation for landlords designed to ensure that tenants are made aware of their rights and tenancy terms clearly and transparently. So for new tenancies, again, from 1st of May 2026, every new tenancy must start with a prescribed written statement that sets out the terms of the tenancy. The exact content will be set out in secondary legislation. We don't have this yet, and we'll make sure that all of our brokers are updated well in advance. So for existing tenancies, if the agreement is already in writing, the landlord doesn't need to change the agreement, but they must provide the tenant with a copy. There'll be a government-produced information sheet. Again, it's not been published yet, but this will have to be provided to the tenants by the 31st of May 2026. And it's designed to bring tenants up to date on the rules without having to renegotiate their contracts. If the existing tenancy is verbal or informal, then landlords must provide a written summary covering the required information, so essentially a statement of terms, by the 31st of May 2026. And this will essentially create a written agreement for the first time in those tenancies.
Okay, and how's that likely to affect claims moving forward?
So compliance with the requirement to issue a written statement of terms where it's required by law will be a precondition to a claim under the updated landlord legal and rent protection policy. So again, once it becomes law, that's going to be a policy requirement.
Okay, and you've mentioned that it's not been prescribed exactly what's going to be in there. What's likely to be in that statement? So
we expect it's going to cover details such as tenancy type, rent, deposit protection information, the landlord's safety compliance obligations, and summaries of the grounds for possession. So as soon as we've got more information about what will be required, we will circulate that. Okay, perfect. Thank you. So let's move on to the policy updates themselves then, because this is the part that our brokers really need to understand. Yeah.
The new cover is being built around the Renters' Rights Act.
Yeah, so the proposed new cover integrates the Renters' Rights Act compliance. So it's been restructured to reflect the new legal landscape, meaning it will be suitable for landlords that are ensuring they're compliant with the new rules.
Okay, so let's walk through some of the key differences. First, the definition of tenancy itself has changed, I believe.
Yeah, so under the old cover, we recognise assured short-hold tenancies, essentially the pre-Renters' Rights Act framework. The new cover specifically talks about periodic tenancies. The which are continuing in force by virtue of the Renters' Rights Act 2025 or new periodic tenancies. So the product is explicitly aligned with the new tenancy structure that comes in May.
Okay, and we're seeing that same alignment in the new compliance related definitions too.
Yeah, the old cover had no reference to a landlord register or, which we'll come on to in a bit, the private rented sector ombudsman, because those still don't exist. The new cover defines them both, and it's built to assume compliance with the Renters' Rights Act once those become mandatory requirements by law.
Okay, and that ties into the new exclusions as well, I believe, doesn't it?
Yeah, so this version introduces a specific exclusion that if the landlord fails to register on the landlord register or fails to maintain their membership of the private rented sector ombudsman once required by law, the policy won't respond. So if a landlord doesn't comply, they could lose their cover. So brokers really need to emphasize this. And these are going to be some way in the future, so don't worry, we will be sending out updates and making it extremely clear what landlords need to do closer to the time.
Okay, and I also believe the same goes for rent in advance. I believe that's changed quite substantially.
Yeah, so under the old policy there wasn't anything explicit about taking too much rent up front. Under the new wording, if a landlord accepts more than 1 month's rent in advance, claims can be excluded. So this mirrors the Renters' Rights Act, which prevents landlords from requiring substantial rents up front as a condition to granting the tenancy. So again, compliance with the Act becomes a prerequisite for cover, and we'll get more into the rent changes later on.
Okay, and something else that's new that you've just spoken about is that requirement to issue the written statement of terms.
Yeah, so this wasn't a policy condition before, and under the new version, landlords must issue the tenant with a written statement of terms in the prescribed form or format before or on the tenancy commencement date. It's now a formal requirement for cover to operate. If they don't issue it, they're non-compliant and the insurer may not be able to support them. And of course, like with the other changes, it only takes effect once it becomes a requirement by law. Okay,
so really what you're saying there, and I think the message for our brokers that are watching today is that compliance isn't optional, it's now central to actually whether a claim will even be considered.
Yeah, that's right. So the policy assumes that the landlord is meeting their obligations under the Renters' Rights Act. So just to recap, we now will require adherence to the 1 month limit on rent in advance, compliance with the new requirements as they go live, including the PRS Private Rented Sector Database and the PRS Ombudsman membership, and issuing the written statement of terms. So if any of these things are missing, it could put the claim at risk. So brokers really need to be advising landlords to build compliant processes if they want cover.
Okay, so a lot of new compliance requirements there for landlords to be aware of. Just looking at the current claims situation then, it's clear that court action is quite costly and slow. How will the new policy encourage quicker resolution in that area?
Mediation. So mediation will sit at the heart of the arrears process with the rent protection policy. The government has consistently indicated that they want to see attempts at alternative dispute resolution before matters reach court in other areas to sort of help the load on the court. So we're already seeing in a lot of money claims mandatory mediation at the start of the claim. Our updated policy will build in mediation for rent arrears cases. In addition to the steps that the policy currently requires the landlord to take if they don't pay, such as contacting the tenant and arranging inspections. If rent arrears continue for another calendar month past the first missed payment, a representative appointed by Alps will invite the tenant to participate in mediation. And then if it continues again for another month, we will look at whether it's appropriate to re-engage with the tenant to invite mediation if it wasn't successful the first time.
Okay, so what you're saying here essentially is that we need to be made aware of any potential issues in good time.
Yeah, I mean we like that anyway, but we would like brokers to encourage landlords to report potential claims early. So early reporting is key. The earlier mediation is invited, the more likely it is to be accepted, and the earlier mediation takes place, the more likely it is to be successful in reaching a settlement out of court. Amongst other things, the reason for this is the further someone gets into financial difficulty, the more chance there is they're simply just going to remain in that property until they're forced to leave.
Okay, thank you. Now, another thing that we're hearing at the moment is that landlords are concerned about maintaining market rent. What are the new rules here?
Okay, so firstly, it's important to say that the government doesn't support rent controls. They want the market really to decide what the value is there. But it is empowering tenants to challenge unreasonable increases. So again, from the 1st of May 2026, landlords will only be able to apply one rent increase per year. Increases must be using the statutory Section 13 procedure. It will require 2 months' notice, and tenants can challenge the increase at the first tier tribunal if they believe it exceeds market rate. The tribunal will not be able to order a rent that is higher than the landlord was seeking, even if it's found to be below the market rate, and the increases will, this is important, will not be backdated either. There can't be any arbitrary rent increase clauses in agreements. They're prohibited, so it essentially will be non-effective. Okay,
and I also understand that there are restrictions on actually advertising rental properties now as well.
Yeah, so bidding wars are banned is essentially what we're saying. So this means landlords and agents must advertise an asking rent, and they can't ask for, encourage or accept bids above the advertised price. And breaches of this could result in a civil penalty that could go up to £7,000.
Okay, so quite a significant fine there if they're caught guilty of it. Tell us about changes to how the rent can actually be taken then.
Yeah, we did touch on this before. As mentioned, rent in advance is restricted. Landlords will only be able to require up to 1 month's rent in advance, and exceeding this could invalidate the rent arrears protection cover. So whilst you can take a deposit in advance, this means that landlords won't be able to insist on rent being paid until the day that the tenancy begins. And this makes rent protection very important. You could have someone move into your property and pay no rent from the day one that they're in there. It also means that getting the rent right is important. All of this means getting that right. They won't want to be inviting rent challenges from their tenants. And with the removal of Section 21, it won't be as straightforward as gaining possession through the no-fault process and then re-advertising the property at a higher price.
Okay, so good news there that you said that, especially for tenants, that bidding wars are no longer going to be well, they're going to become a thing of the past, aren't they? So, circling away slightly, let's just take a quick look at sort of the discrimination side of things, as the Renters' Rights Act also takes a firmer stance on discriminatory letting practices. Can you just tell us a little bit more about that quickly?
Yeah, so it makes it unlawful for landlords or agents to refuse someone simply because they have children or receiving benefits. So previously, I know it doesn't exist anymore, but you may have seen no DSS style exclusions in adverts. They're gone. You can't do that.
Okay, and I think that's important for our brokers to understand from an insurance perspective too.
Well, yeah, so any insurance terms that try to restrict landlords from letting to those groups are unenforceable. They have no effect. It's also important to reassure all landlords that this does not stop them from carrying out proper referencing. You can still assess the affordability and suitability. You just can't reject someone purely because of their family status or the income source.
Okay. Now, you mentioned before about the importance of referencing. If landlords can no longer rely on Section 21 and must use this ground-based Section 8 system, referencing clearly becomes far more important now.
Well, I would argue that referencing has always been very important, and it's always been a requirement for policy operation. It's perhaps more important for sound business practice. Failure to obtain and produce a satisfactory tenant reference could mean we decline a claim. Possibly one of the more frequent reasons that this might happen. So I think what I'll do now is just briefly go over the referencing criteria for the policy, which there's no proposed changes to this. So it's quite straightforward, is that there's no outstanding county court judgments. The tenant hasn't had any county court judgments in the past 3 years. ID checks, so we ask for 2 forms of ID and one that's photo ID, and evidence that the tenant or tenant's gross monthly income is at least 2.5 times the monthly rent. We do have a list of recommended referencing firms on our website. I'm just going to stress now that we've got no affiliation with any of them. We don't take any commissions from any of them. It's there to help customers, and it's important that when you go to a referencing company, you're making sure that the referencing company knows the criteria that you want referencing, so it aligns with the policy. It might be tempting. They'll have cheaper options on there which do maybe more basic checks, but the landlord needs to ensure that the reference is correct for cover to be in place.
Okay, so just for clarification for our brokers, when should the referencing be done?
Again, this hasn't changed. The reference should be obtained within 1 month of the start of the tenancy. So before it starts, but within a month, which means that it will need to be redone if the reference has been done more than 1 month before the start of the tenancy. And another important point actually is that for a new tenancy, cover is in place from day one. If the policy is purchased before or coinciding with the start of the tenancy, if you take the policy out partway through the tenancy, there's a 90-day exclusion on being able to make a claim on the policy, unless it's a renewal. So it's best to encourage landlords to take the policy out at the start of the tenancy or before, to make sure that they are covered from day one. This is another more frequent reason. We don't see a lot of it, but it's a more frequent reason for rejection because it's clear that there's an issue has arisen and then a landlord decided to take a policy out afterwards. It's not really how insurance is designed to work. No, that's a very good point. And we'd obviously recommend now that landlords get Renters' Rights Act ready and get the policy now. Yeah. Don't wait until they've got an issue to then go and buy cover. Now, a lot of heavy stuff there for people to digest. We've gone through a lot of information, so we'll move it across to everyone's favourite topic, pets. Let's discuss the changes regarding pets, which has received a lot of attention during the lead up to the Renters' Rights Act receiving royal assent. So it under the new rules, landlords will not be able to unreasonably withhold consent when a tenant requests to have a pet in their property. And they must respond to any request that's made within 28 days. A key change is that, and in earlier iterations whilst it was being debated as a bill, is that it was being proposed that landlords would be able to take out specialist insurance and pass this on as a direct cost to the tenant when they requested pets. That's gone. They can't do that. So you can't put a rent up or charge a fee for having a pet. And whilst you can take a deposit which can cover damage, some damage caused by pets, some pets can be destructive. And if it exceeds this cap, a landlord might have to pursue the amount over the deposit through other means. So what we'll quickly talk about is that we do have a pet damage product which is designed for this, that covers damage specifically caused by pets.
Exactly, and I think one thing to note here is the benefit of that product is that it can be sold as a standalone product or as an add-on. So I think this flexibility is essential because a tenant can request a pet at any time during the periodic tenancy, not just at the start. So I think for our brokers, I think landlords should be made aware of this product so that they can swiftly obtain cover when a pet request is approved. Selling price out to the brokers goes out at £99. It's got a max retail of 120, which provides £5,000 worth of cover, which for most cases I think will be significantly higher than that deposit cap under the new rules. Looking ahead then, Nick, we also need to make sure our landlords understand the legal roadmap ahead of them, because the next few years brings several significant changes, doesn't it?
Yeah, so we've mentioned a few dates already, and we will continue to provide updates as soon as regulations are confirmed, so brokers can pass this information on to their clients. But essentially, the direction of travel is clear: higher standards, more compliance, and stronger protections for tenants. So over the coming phases, as the government are calling them, landlords will face a series of milestones. The first one, which we've not mentioned yet, comes in this month, on the 27th of December. There will be enhanced investigatory powers for local councils, giving authorities the greater ability to request information and take enforcement action against non-compliant landlords.
Okay, so we've not touched on this yet. We've been looking ahead to next year. So before we move into the 2026 reforms, can you explain how these powers are designed to strengthen enforcement across the private rented sector?
Yeah, so from, again, 27th of December 2025, local authorities can require landlords and agents to provide documents or information if they believe it's reasonably needed to check compliance or investigate a potential issue. So it's not going to be random data trolls. They have to have a legitimate investigatory purpose, but they have set this threshold quite low.
Okay, but what you're saying is that they don't need to actually prove anything first.
Yeah, that's exactly it. So they don't need hard evidence of anything before making a request. So if a tenant raises a concern, or they spot something that might not be right in an advert, for example, or if they just need to verify that the landlord is meeting their legal duties, they can issue a formal information notice, and landlords have to respond within the timescale that's been given to them.
Okay, and I believe that non-compliance with this is an offence, isn't it?
Yeah, so providing incorrect information or simply not responding can lead to penalties. Councils can also enter a business premises like a letting agent, their office, to inspect records where necessary. So even before the big reforms go live in May next year, enforcement is tightening up.
Okay, thank you. I think the key message for the brokers here is that landlords need to be audit ready by the end of this year.
Well, yeah, so having documentation organised, accessible, tenancy agreements, deposit protection information, that's a key one. Safety certificates, rent records, inspection logs. From December onwards, councils could be a lot more proactive in using these powers. We already see with claims, the first step that we normally take is to ask landlords for documentation, and it is all too frequent that it's taking weeks for this documentation to actually be produced. So have it ready, stay compliant, and have good record keeping.
Okay, thank you for clearing that up. Let's move on to the other reforms then into next year and beyond.
Yeah, okay, so the first major shift, if you will, that date again, 1st of May 2026, phase one of the implementation. So just to recap, we've mentioned, I think, most of it already. We've got the abolition of Section 21, the almost universal move to periodic tenancies, the revised Section 8 possession grounds, the updated rent increase rules and rent in advance, and the new protections relating to pets. So this phase puts greater emphasis on landlords having correct documentation, following the correct processes, and being able to evidence compliance.
Okay, and what about the changes that are coming in after that?
Yeah, so again, as already mentioned, this late 2026 phase 2 begins. So this will start with the launch of the private rented sector database, which will require landlords to register and pay an annual fee. And I expect to upload key safety and property information. So you're probably going to be expecting things like EPC ratings, gas safety certificates, EICRs, the electrical certificates, and registration, as already mentioned, will become a precondition for the rent protection cover, but also for most possession grounds to be used. By 2028, then phase 2 will continue with the mandatory membership of the private rented sector Ombudsman, which will provide tenants with a free and binding dispute resolution route. And again, maintaining membership of this will be important for insurance cover to remain in place.
Okay. And looking a little bit beyond that as well, obviously some big changes on the horizon relate to property standards. These aren't coming in immediately, I believe, but I think the brokers need to be aware of them because I think they will shape the direction of the sector over the next few years.
So it's important to be aware. So one of the major developments we expect is the extension of the Decent Home Standard to the private rented sector. At the moment, Decent Home Standard or DHS applies mainly to social housing, but the government's roadmap makes it clear that a similar statutory standard for private landlords is being developed. So once introduced, it's going to set minimum requirements for the condition of the property. So this will cover things like repairs, the facilities in the property, safety, thermal comfort as well.
Okay, and I think the implication for landlords here is that it's not just going to be guidance, is it? It's going to have enforcement teeth with it.
So when DHS, Decent Home Standards, rolled out in the private rented sector, non-compliance is expected to carry the possibility of civil penalties and in very serious cases criminal prosecutions. So the direction of travel is very much towards a higher baseline standard across the entire rented sector, so not just social housing or higher risk properties.
Okay, and we're seeing a similar push behind the extension of Awaab's law as well.
I'll quickly explain what Awaab's law is. So it was introduced following the tragic death of a 2-year-old called Awaab who died from prolonged exposure to damp and mould in his family's social housing. So the law is designed to make sure this doesn't ever happen again. It will impose strictly legally enforceable deadlines on landlords to investigate and fix serious hazards to health such as damp and mould and other risks. So Awaab's law is currently being introduced in the social sector, and the government has committed to extending it to the private sector. And what it'll do is set legally enforceable deadlines for responding to serious hazards, particularly damp and mould, and for carrying out remedial work. So if a landlord misses those deadlines without a valid reason, tenants will get stronger rights to escalate the issue, which could potentially lead to court action.
Okay, so the long-term picture is higher expectations around the condition of the home itself and much faster response times when problems are reported.
Well, yeah, it's all part of the same movement. So better property standards, clearer obligations on landlords, and stronger enforcement if those standards aren't met. So message to brokers, I suppose, is prepare clients now for this shift, because it will require ongoing investment for landlords in maintenance, inspections and record keeping. What we're seeing is the overall journey will require landlords to invest in the quality of homes, invest in the compliance and ongoing management if they want to remain protected and competitive in the new landscape. Okay,
and again, this is something else that we can help with. Obviously, you touched on there things like thermal comfort, health hazards within the property. Obviously, our landlord home emergency cover would provide assistance in the events of things like boiler failure, pest infestation, things like that, that would impact the habitable condition of the property. Again, it's just another tool in the belt of the brokers when having these conversations with the landlords. And again, whilst we're on the topic of tools to help, we appreciate that many landlords are concerned about the rising costs across the board. And another way that brokers can help combat this is to perhaps increase the excesses on the core insurance and then offset it by using the landlord excess protection product. It may also go some way to help lower the overall costs of the legal expenses cover too, if they wanted to sort of go down that route. Now, Nick, as we've discussed, the Renters' Rights Act necessitates a transformation into how landlords operate, so shifting from a process-driven eviction system under Section 21 across to a compliance-driven and grounds-based legal framework.
Yeah, so an important takeaway is that for brokers is that there are opportunities here. So you really want to try and, I suppose, operate as the conduit between the legislation and the landlord. So we should emphasise that comprehensive legal expense insurer and rent protection cover is a safeguard against financial loss, and we think in the new era really should become essential. It should be a staple like your core insurance. So by adhering to requirements like referencing early claims notification and the landlord's sticking to all the legal obligations, such as the forthcoming database, Ombudsman registration, they can ensure that they're going to have business continuity and that their legal protection will remain operative if they need it. Okay.
And with this increased compliance burden on landlords, do you think that the private rented sector will shrink?
I mean, not necessarily. There are certain market forces out of control, such as house prices, but and landlords will inevitably have, as we've mentioned, additional overheads, including the recently announced increase in tax for rental income from properties. And there will be other challenges. So you've got the increased exposure when a tenant stops paying, but this can be offset with insurance. So the emphasis, as we've said, is on compliance and good standards. So really this could benefit a lot of the landlords who are already following good practices and maintain good properties. I suppose rogue landlords, if you like, could just be pushed out the sector altogether. And we might even see a natural increase in the sort of the market rent for rental properties. And if there's a gap left by landlords that can't meet these standards or aren't meeting these standards, this could, I suppose, be filled by the landlords who are already doing this and bring in more quality housing stock into the private rented sector. And in any event, these are the landlords that we would be encouraging brokers to be targeting. So I don't know, but not necessarily.
Okay. Well, thank you for that, Nick. There's obviously a lot of information, a lot of useful information there. Just a reminder to our brokers that our landlord legal expenses and rent guarantee products are available already through inception via our Communicate portal and on OpenGI. There's also an ever-growing knowledge base on our portal where you can find the answers to a lot of the common questions, and I think this will certainly be growing with a lot more let property queries in the coming weeks. Just to touch on the 90-day restriction on policies incepted mid-tenancy, now is a good time for landlords to insulate themselves ahead of the upcoming changes with the Renters' Rights Act, and again before the prices go up next year. One thing that I wanted to briefly touch on before you go, Nick, something that we've had a growing number of inquiries about, professional guarantor insurance. This is where a regulated provider steps in as a corporate guarantor for the tenant, guaranteeing the rent and certain liabilities, sort of in place of a traditional individual guarantor. It's becoming increasingly popular, particularly for students, young professionals, tenants without a strong UK credit history. Can you tell us a little bit more about that?
Yeah, so I just wanted to mention this because there's not a lot of options out there for students, for example. So a professional guarantor service can offer landlords a higher level of reassurance because the guarantor comes from an institution rather than an individual. We have had some brokers asking whether this is something we can support, and we are currently discussing the possibility with our underwriters to see whether we can bring a solution to market.
Okay, perfect. So I think the message to the brokers is that if that's something that you or your clients would be interested in, please let us know. The more appetite we see from you, the faster we'll be able to progress any sort of product development and progress those conversations with the underwriter. As always as well, if you can't find answers to any of your questions on the portal, or you have any specific policy questions about any of our products, please give our broker support team a call. They're always on hand to help. What we're going to do now, that's the end of the webinar, so thank you for your time, Nick, but I'm not going to let you go just yet. We're going to have a look at some of the questions that you've submitted whilst we've been talking, and by the looks of things, from the messages that Tom's been sending me, there seems to be quite a lot of questions, so I hope you're ready. We'll have a look at them, we'll answer as many as we can. Any that we don't get through, we will try and answer in the follow-up email after the webinar. So we will start off with, what is a reasonable reason to refuse a pet? We'll go back to the pet topic.
That's a good question. Well, for example, you're not going to allow someone to have a Great Dane in a one-bedroom flat. This is evidently unsuitable. So it's subjective and would be open to challenge. So you have to. There's an objective standard there. You'd have to look at what would the reasonable person suggest would be a good reason to refuse. You can't just refuse. You won't be able to refuse just on the basis that I don't want a dog in my house because it might cause some damage. If you look at a privately owned home, would it be objectively reasonable for someone to have that type of animal in that home? And that's the baseline I'd be looking at.
Okay, thank you. Circling back to referencing then, do we need to re-reference the tenants after a specific time period? I think you touched on this, didn't you?
So you do need to look at the short answer is no. But if something changes in terms of rent, so it's always worth going back and checking the reference if you're thinking about putting the rent up, and checking if the tenant fits the affordability criteria. You don't want a tenant in your home who can't afford to be there. So if you're thinking about putting the rent up and it takes you past that threshold, then you might want to go and speak to the tenant, or I would recommend going and speaking to their tenant to find out if their circumstances have changed. Remembering that you can only do one rental increase per year, you expect people's wages to go up in line with private sector wage increases, or they might be public sector workers. So you would expect that their wages would move with the affordability criteria, but I would be recommending going back and checking it. Specifically of a reference, there's not necessarily a need to go back and re-reference it at any particular time.
Okay. Next question then, will all ASTs automatically roll onto the new system with effect from the 1st of May, or will they need to run through to the end of the existing AST terms?
No, so it'll be from the 1st of May. They will turn into periodic from the 1st of May. So they won't be able to go to the end of the term and then serve notice in line with the end of the term. They will automatically all become periodic on the 1st of May.
Okay, thank you. Another one we've got here, you mentioned that the tenancy cannot be refused due to status or benefits. Does this mean that insurers will not be able to choose whether they offer cover for DSS tenants, for example, or is the option still there for insurers to only cover to working tenants?
That's right. That's exactly what it's saying. Is you can't discriminate on that basis. However, you can set. We've clearly set affordability criteria. So if someone's not working and they are only in receipt of benefits, then you would thought that would exclude them for suitability for a lot of the private rented sector simply through affordability. So yeah, you can't do it. You can't discriminate on benefits or family status, so if they have children, but you can on whether or not they meet the affordability criteria. Yeah.
Okay. Perfect. And another pet-related one here. It says, "Isn't the pets reform unfair? What if a dog barks and whines all day?"
Well, I guess so. Well, I don't know if that's unfair. You don't know a lot of the time if you're getting an animal, especially a young animal. You don't know what that animal is going to be like until you get it. Whether this affects the landlord or not, it may fall under antisocial grounds. There might be a nuisance factor there if you've got a problematic dog, but I guess you don't know until you get a pet what the pet's going to be like. But that's the same if someone's got their own home, you're going to be in the same situation. Yeah.
Okay. And I think we'll take one more one here. If the landlord has a letting agent, will they be responsible for bringing the tenancy agreement and database information up to speed? So where does that responsibility lie?
The ultimate responsibility to be registered lies with the landlord. If that changes, when we see secretary legislation or the database implemented, we'll let you know. But no, it's the landlord's obligation. If they've instructed an agency to assist them with the management of the property, then great. But the ultimate obligation is on the landlord.
Okay, perfect. Perfect. There's still a lot of questions there as well, and they're still coming through. So what we'll do is we'll endeavour to answer as many of those as we can with the follow-up email, just to make sure that everybody's getting an answer to the questions that they've thrown in. So thank you for all your input, for everybody that's watching. It's always nice to make sure that we've got some questions at the end, and we get to put Nick on the spot, which is always good fun. I want to thank you all for watching today, for spending the time with us. I hope you all have a lovely break over Christmas when we finally get there. And we look forward to seeing you at the next webinar, which the details of which will be coming out soon. Oh, Tom's just sent me a message. So if there's all the questions, any questions that you've got, if you send to tom.thomas@alpslimited.co.uk or to marketing@alpslimited, that's alpsltd.co.uk, if there are any more after the webinar is finished as well.